Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Hi, and welcome to the podcast. You know, this podcast is designed to explore and discuss the issues that often come up in trust and estate disputes. And as you know, I'm an attorney in Southern California practicing primarily in the area of trust and estate litigation. There are times, however, when family law matters and estate matters, whether present or prospective, collide. And we're here to talk today about alternatives to family law litigation with our guests, Sheila A. Williams, attorney at law, and the Honorable Dale R. Wells, retired judge. Now, the podcast people need me to tell you this, and I need to say this, that this podcast is not designed to give you legal advice over the podcast. If you need legal advice, you can reach out to a lawyer of your choosing in the area in which you reside. Want to introduce our guests. Sheila, welcome aboard. And Judge Wells, welcome aboard.
Thanks for having us.
Give a little introduction to both Sheila and Judge Dale R. Wells. Sheila has been licensed to practice family law, licensed to practice any kind of law, but her specialty is family law in California for over 40 years. She's a member of the California Bar Association, the Desert Bar Association. She is very intimately acquainted with family law matters. She's been a law professor at the California Desert Trial Academy College of Law. She's got a host of accolades that she's achieved over the years. She's top lawyer, several years running in our local publication, Palm Springs Life Top Lawyers magazine, and has been a fixture in the family law courts in Southern California for many, many years, many decades. And with her is the Honorable Dale R. Wells, who is a judge retired, who has over 30 years experience, 19 years on the Riverside County Superior Court bench, and a former supervising family law judge for Riverside County. And he's got extensive experience in teaching judges and attorneys throughout the county, throughout Southern California. And it's just a pleasure and an honor to have them both here to talk about these very important topics. And welcome aboard. Thanks for coming on to the podcast. And I'd like to start by asking this question. When we talk about alternatives to family law litigation, what exactly do we mean by that?
Well, there are all kinds of ways of handling conflicts between people. And they go from on one extreme where people can cooperate with one another, work respectfully with one another, and come to an agreement between themselves without having to involve the court process, to another extreme where basically a judge or a commissioner or a bench officer makes all the decisions. Between those two, you've got processes that allow either more or less control over the dispute between the parties and someone who's actually making the decisions for the parties. And so that's what we're looking for, ways of avoiding going to court and getting what both sides really need and what they really want.
All right. So when we're talking about it, the process of mediating, I guess, a family law dispute, how does that start? Or what is the process that a couple that wants to achieve a resolution of their dispute, their marital dispute, but they don't want to go through an expensive court process? How do they do it?
Sure.
There are several ways, and later we'll talk about the concept, but our family law courts here in the desert don't order parties to mediate cases. It's a voluntary process. And so it starts with two individuals who sometimes will have lawyers who want to engage in a process that is informal, that's cost effective, and efficient. So that's really the start of the process. And many people are not familiar with mediation. And that's one of the reasons we felt this podcast would be perfect to put out in our universe here, and especially in the Coachella Valley, all of the alternatives that are available for people who go through family law mediations and other processes other than litigations.
And I think you have some a presentation, a slide presentation that might be educational to our viewers. I know a lot of folks, when they're going through a dispute, a marital dispute, it might be one of the most frustrating experiences in their lives, very stressful. And it seems like a mediation in the family law arena could greatly alleviate a lot of angst, a lot of anxiety, a lot of frustration, probably save a lot of money. What can you tell our viewers about that?
There are several major frustrations that litigants, and by the way, they're lawyers as well, experience in the family law arena. The first and most important is delays that cost time and money. You don't have to spend much time at all in a divorce case before you realize the long and arduous journey you're about to get to resolve your issues. In my practice, a typical family law action will take anywhere from 18 months to 3 years if we go through litigation. There are certain temporary orders that judges can issue, known as requests for orders. And it may take several months from the time you file that request until the time you actually have your day in court. And when you get to court that day, you find out that you are one of maybe 20 cases on calendar for that morning. The courtroom is packed, and it's not a very user-friendly atmosphere because everybody is stressed with regard to what will ultimately happen. Now,
it seems like, it's nobody wants to have a family law dispute. Nobody wants to have to face the termination of a marriage. People are coming to you, and they may have religious prohibitions against it. Things didn't work out. They're frustrated with their spouse. They don't know what's going to happen with their children, and all of a sudden, all their assets are up in the air. They don't know what's going to go on. So is that part of the frustration? People are coming into it frustrated already after having had frustrations in their marriage that put them in the point that they're seeking a dissolution, which is probably one of the most unfortunate things that people are going to face in their lives is something like that event. And so making it shorter and getting to the right answer or the acceptable answer is best. And is that what you're trying to do with these alternative measures, because the court systems don't seem to be able to provide it necessarily. Is that a fair statement?
And also, Peter, it's important. It's not the right decision that creates the frustration. It's the time it takes to get to that decision. If you are in the middle of a custody battle, by way of example, and it takes you 3 months to get a hearing, there are no orders in place. The parties are having their issues with regard to timeshare and scheduling their kids. So that's a very big frustration that also, by the way, translates into money, because while your lawyer is traveling to court and waiting for your turn out of 20 cases, you're on the clock paying legal fees for your lawyer's time.
If I could pause for a moment just on that issue, Sheila, we're talking about your kids. We're talking about visitation and all those types of things. And what a big issue, right? What a big issue. And at the outset of a matter, if you knew that it was going to cost you however many thousands of dollars it might cost you just to be able to establish a visitation schedule or whatever, wouldn't it be better if with the person that you had this family with could find a way to meet, such as through your service, to work it out in a much more like you did before, at some point in your life, you got along enough to have children, and now you want to get together to see, oh, well, let's see if we could work this out. And we have a judge here who's seen 19 years of cases coming before him, and a lawyer who's done it for 40 years. And you've seen all the frustrations. You know what it is. You're going to be able to tell these people, look, this is how it's going to go. You guys can't control the time it takes to get through the process, but you're offering the service to make that process shorter.
One thing, Peter, that I used to tell folks all the time, every day, in fact, when I began my calendar, is I told them, there was a time when you used to like this other person. Think back to that time. Everything was not always like it is right now. And that's one of the big problems in family law, is everybody looks at it, especially in a court setting, as adversarial. And it doesn't have to be adversarial. Even in court, it doesn't have to be. But certainly, if you can avoid going to court, you can minimize the adversarial aspect of the litigation.
Right. And so when do you think, when you're considering alternative dispute resolution, when do you think is the time to do that? Is it right at the beginning, or does it take people a little bit of time to get up to that point? Is there a time when the course towards a mediated result ripens, in your opinion?
I believe, Peter, that at the outset, when I meet with a client, when I was in litigation, one of the first things that I need to tell them is that we have these other options. Not only do we have these other options, but to explain to them the difference between coming to mediated agreements versus going through litigation. If you don't have that conversation in the beginning, the first thing that will happen, the first document filed with the court will be a declaration about all the things you did wrong. And that will then create the atmosphere where, in my opinion, it becomes less possible for people to look at alternatives, because now they feel they need to defend themselves. So I think you start in the beginning, educating your clients about the process. There are things that we have to do to get ready for example, mediation itself, but we should start telling clients in the beginning, we have these alternatives, and let's start moving toward that direction rather than filing requests for orders and taking depositions. We still have discovery and things like that to do, but it should come down to two people who have control over their futures.
And one of the things you've put up on the screen here on this slide is embarrassment of litigating in public. I mean, that's a factor that people might like to avoid if they know about that prospect at the outset. Of course, they probably think about it. They know they're going to divorce court, but if they've never been to court at all, and most people haven't been to court at all, probably in their whole lives until maybe this moment, you've probably had many people, I would imagine, in your respective practices, and Judge, you've seen people come, and this is the first time they're in court is when they're getting a divorce, right? That's it. And now it's all
court and family court.
What's that?
Traffic court and family court.
Right. And so
what people don't understand, Peter, is that, again, remember earlier I said on a morning calendar, there will be probably 20 cases. So everybody gets to wait their turn to tell their story. And of course, by the time they get there, they've heard all kinds of embarrassing things that people put on the record and lawyers and litigants talk about in a public setting with people you are totally unfamiliar with. And that is probably one of the more frustrating parts for folks who go through family law, because they don't know that. They've not been to court before. They sit and they listen to, we know about the famous cases of the paparazzi and the celebrities, and everybody wants to know about their dirt. But in our situation with your typical family law case, that frustration of having others listen to some fairly ugly stories that people sometimes make up and some are true.
And going back to what Sheila said a few minutes ago, if someone throws out some dirt about you, then you feel like you have to respond, especially if you're in a courtroom full of people who are watching this play out, and you feel like you have to answer for yourself. And so what winds up happening is, instead of being a situation where you can actually talk calmly, you find people getting more and more emotional and less reasonable in the way they present themselves.
Because people are getting defensive and they feel that they need to fight back, and it becomes a war of attrition of the family finances is really what it becomes. I mean, I experienced that when we try to resolve estate disputes, which is a little bit like family law after death in a sense, and you offer people the opportunity to work it out, because otherwise one of the heirs is going to be the lawyers, right? It's going to be people that and you want to try to minimize that impact of attorney's fees as much as you can. I just had to ask the question because sometimes it seems like people need to be I don't know if it was the right way to put it. People bloody themselves a little bit before they resign themselves that they will go to mediation. Maybe that's the natural path of people who have come to loggerheads. Maybe it takes a little while, but you as a judge, your honor would talk about it early on, pretty much, right?
Absolutely. And one of the things I noticed in all of my years doing family law and sitting on the family law bench is that people are rarely at the same point emotionally at the same time. By the time one person has decided to call it quits and file for divorce, the other person hasn't really started down the road of thinking that way. And so what you have is people who are basically at opposite ends of an emotional spectrum at various times in the case. So what you need to do is you need to get people on the same page, so they're both approaching it rationally, not emotionally.
And can a private judge help with that, do you believe?
Absolutely. That is one of the triggers of this alternative dispute resolution process, is to take it out of the fighting stages. Because once you go down that path, let's say you've had 2 or 3 hearings and 6 or 8 months have passed, the parties have thrown dirt at each other, the likelihood of those folks going to mediation becomes slimmer every single day, because they still feel that they need to get their pound of flesh.
Mm-hmm.
There's something you put up there, less experienced judicial officers as a family court frustration, and I'll guess at what that means, but I'll ask as well. But my guess is that, as it happens, sometimes you might get someone on the bench that's not particularly familiar with family law matters, and it's a very technical area, like probate. It's very technical. It's very nuanced, and I'm going to say that the judicial officer has to have a temperament to be able to handle it in a way that's constructive to not only handling the calendar, but trying to achieve some level of justice for the family in the best possible way. And it seems like, boy, why couldn't you do that outside of the formal environment of a courtroom, across the table from the other person, while they're sitting in front of you and you're explaining things to them in a way that they're going to get to anyway when they finally construct a marital termination agreement, and then and do it fairly and with everybody learning kind of at the same time. That seems like a really good way to do things.
And one thing, Peter, every one of us, you're a lawyer, I'm a lawyer, Dale was a judge for many years. We all start the learning curve at a different time. So in my experience, in 4 decades in family law litigation, I have on a regular basis been assigned to judges who were newly appointed to the bench, who used to be prosecutors, who've never handled a family law case in their lives. They go to judge school, of course, but it takes that experience of seeing the nuances and how they play out before that bench officer can have a better sense of dispensing justice. Remember, family law courts are courts of equity. What's fair? So we can read the black letter law and see what it says, but every situation is different. So the level of experience is not always there. I'm not putting down our bench officers. We have fantastic bench officers. But what we offer in the process that we look at with mediation and private judge work is 4 decades of experience for me, 3 going on 4 for Dale. And we've seen it all. There aren't many things that I haven't seen in my practice of law. So when you come to a process like this, that frustration of feeling as if, well, I don't know if this judge really knows what they're doing. The final point I want to say on that is that here's how you handle newly appointed bench officers. You must educate them.
Mm-hmm.
And that education comes not as I know more than you, but here's some examples of things that have worked and that could continue to work. And the way you present yourself as an attorney to those new bench officers, I think is a very good learning tool, because they'll see that it takes, and we'll see later in this podcast, sometimes you have to think out of the box.
Yeah.
Right.
Even in my nearly 2 decades on the bench, I regularly told attorneys, please educate me. And they would educate me by writing up briefs that would tell me this is case law that applies here, and here's why I think it applies here. In other words, they're persuading me, not just teaching me. And I think every bench officer needs to be that way. But like Sheila said, oftentimes my observation was that the people who got assigned to family law really were not equipped, because they hadn't been trained in family law. Family law is a different animal than criminal law, for example. I did family and I did criminal. And I used to tell folks that when I was doing criminal law, I was dealing with bad people on their best behavior, because they wanted the best outcome they could get. When I was dealing with family law, I was dealing with good people on their worst behavior.
Right.
There's no one who can be meaner than a good person who knows that they're right. And
Right.
So a lot of times it takes a lot of psychology to be able to work with those folks in a court setting, not only to make the right decision, but also in a sense to persuade them that it's the right decision. So you're educating them, they're educating you, and it's a process that you have to go through, and every judge has to learn that process. So we'll have commissioners that get hired by the judges. We'll get judges that are appointed by the governor who come out of the criminal law background. They haven't the experience of dealing with family law situations that we've had after years and years and years of doing it.
And it takes a while for people to appreciate, and then in any litigation, when they're going down to court and they're seeing the process moves. As the process moves, it's Riverside County bench is fabulous bench. I have a high level of respect for all the bench officers I've ever appeared for, all of Southern California, but there's a process to keep it fair. And once people start talking in the language of litigation, that's a long-term language. It's interrogatories. It stretches things out. It definitely stretches out that conversation. Mm-hmm. And so mediation of these types of disputes through a private judge could really save you some time and really save you some money. Do you have some materials that illustrate these things where you talked about thinking out of the box?
Sure.
There's 2 people yelling at each other. You can avoid that, right?
Exactly. That's the whole idea. Avoid yelling at each other, whether it's lawyers or litigants or both. And you never know where the animosity comes from. It can come from the client. It can come from the attorney. You could have 2 attorneys that are both absolutely convinced that they're right, that their position is right, and there's no alternative. And we really need to start that process of alternative dispute resolution early on. I've got a little brain teaser that I use sometimes when I'm talking to attorneys. And that is, look at this little set of 9 dots in a box. And can you use 4 straight lines to connect all 9 dots without lifting your pencil or retracing any lines? And you can play with that all you want.
I'm not going to try that right now.
Okay. And the likelihood is you're not going to get it unless you think outside of the box. The only way you can do that is by taking one of the lines outside of the box. And so that is that's the idea that I want to get across to folks. You have to be thinking of something other than litigation. And that's what alternative dispute resolution looks for, ways to resolve family law issues outside of the adversarial litigation box. A lot of attorneys, and this is true largely because just the practice of law is adversarial. A lot of attorneys never think of any alternative except, okay, we're going to file a case, we're going to get the other party served, we're going to go through the process of discovery, we're going to get our temporary orders, we're going to eventually wind up at a trial and have everything resolved by a judge. And that's kind of a linear progression that attorneys often think about.
As if that's the only way.
As if that's the only way.
And it's not the only way.
No, it's not. As a matter of fact, back on July 20th, 2007, the Board of Governors of the State Bar adopted a California Attorney Guidelines of Civility and Professionalism. The Riverside Board of the Riverside County Bar Association adopted it less than a year later on March 18 of 2008. And one of the things it says is this is Section 13. An attorney should raise and explore with the client, and if the client consents with opposing counsel, the possibility of settlement and alternative dispute resolution in every matter as soon as possible and when appropriate during the course of litigation.
I am so glad that you're reminding people of that. But let me interject a question here. You get the client that comes in and they want the bulldog lawyer. You've heard that term before. Mm-hmm. And I can be the bulldog lawyer. You could be the bulldog lawyer if we have to be. And you have the knowledge and the toolkit to be able to do that. But what's best for the client? And I always try to put it, zealous advocacy in court, wise counsel in private. And the wise counsel in private is right there, right? Because, and actually that's a responsibility of the lawyers to explore that. And, you know, you're going to have plenty of work. If you do that, it's just an issue. What's the best for the client? What's the best for the family? What's best for the kids that you want to send to college to in the future right now, right? What's best for their mental state? Explore these opportunities as soon as you possibly can. Don't mean to be getting on a soapbox here, but that seems to be what you're saying. And the rules tell us to do that.
Absolutely. And this is not just something you need to do once at the beginning. This is something you need to raise periodically throughout the process. You know, and sometimes what you need to do is parse out the issues. I have found that there are a lot of times there's one issue that is the pivotal issue. If you resolve it, everything else falls in place. It's kind of like setting up dominoes. I ought to have that on a slide. Setting up dominoes so that you tip one and the rest of them just fall. And what you have to do is find that issue and see if there's a way of resolving that issue outside of going to litigation. Because if you can do that, then you can build on the process of cooperation, working together to come to a solution rather than litigation.
And just a point to emphasize what Dale just said, and in my practice and working with other lawyers and clients, of course, that's exactly what happens. Every case has maybe one, maybe two issues, maybe two. And I'm going to put aside custody and visitation for the following reason. I tell people, would you prefer that a stranger decides your custody visitation issues? Or do you think that you as parents should do what's best for your child? And so I think at the end of the day, folks want to know that they're either more powerful because they have more money, or they want to have control, which is why many relationships end. But I think at the end of the day, our clients need to understand that the constant bickering over little things, who's going to get the car, who's going to get the Jeep, who's going to get the golf cart. No, we have big issues that need to be resolved. And I think Dale is correct. If you hit the nail on the head with that domino effect, you get those big issues off the table. Everything else generally just falls in place 9 times out of 10.
I'm going to go back to a question that I had earlier about the ripeness of when you go. And the rules say as soon as the dispute occurs is when you should start thinking about it.
Yes.
Do you ever have the experience as a practitioner, Sheila, that if you talk about it too early, your clients might think you're being weak? and you have to correct them from that. And when you were on the bench, would you ever say something along the lines of, look, settlement doesn't mean the lawyer can, I know these lawyers, they can do whatever you want them to do, they can do it. And they tried a bunch of cases in front of me, and they can try yours, but you could avoid that event in 18 months by trying to get together now. And we're not telling you what to do, but this process is, again, it's the language of litigation. It's a long conversation, much longer conversation than you could have, and be much more frank and much more personal and much more, I'm thinking, humane, actually. Even if people are splitting up, they could still think about, what's good for their kids and what's good for each of them going forward. How do you address the client that wants to get the other side?
Right. So from my perspective, if I had a client who came into my office and gave me instructions to take the other side down, that's not a case I would accept. Not going to do it. Back to your earlier question, Peter, here's why you talk to the clients in the beginning about alternative dispute resolution. See, 6 months or 8 months down the line, and you still have nothing resolved, and you've already spent $20,000 or $30,000. And when you bring it up at that point, here's how clients feel. Well, I didn't know that there was some alternative. Maybe I should have looked at that. When you tell them in the beginning, and maybe the client says, no, I don't want to do that. I don't want to go through alternative dispute resolution. So when you get to that 8-month mark and the bills are constantly going up and you're going to court every other month and nothing's getting resolved, then you've done, in my view, as an attorney, my due diligence to explain to the client the time, the cost, and the efforts that it's going to take to get to the same place. We do full day mediations sometimes. We do mediations in different kinds of fashions as issues come up, so that people know that there are alternatives. But that, to me, is the reason why you want to tell them, because after a while, they're going to get tired of paying your bills, and they're going to get tired of having to take a day off from work where they're not getting paid to go to court to sit for the morning and maybe get a ruling, maybe not. So you need to tell people, and you need to tell them on a regular basis. And whether they accept or not, we can't control our clients. But I think once you put those kinds of issues in front of a client, they have to look at it more carefully, because remember, everybody knows somebody who's gone through ugly divorces. Some people know about people who've gone through very smooth divorces. So when they come to you with that mindset, we know they've seen this before. Maybe some family member, maybe your sibling, maybe a dear friend has gone through years and years and tens of thousands of dollars of litigation. These are the people who need to hear this.
And a practice point for attorneys that are out there is that this is saying you've got to explore it. You should. I mean, you should. So it's pretty unambiguous that you should really try to start to do that, because that is in the best interests of the client, and you don't want to have a situation where people, they can't go anymore, and then what happens? They're left with they're out of gas. And they still haven't resolved their dispute. So
or Peter, and the alternative in my business, then enter lawyer number 2, lawyer number 3, lawyer number 4. I had a case where I was the original lawyer. I was lawyer number 2 on a case, and the other side was, by the time we got it settled, at lawyer number 8.
That's
because if you don't like what your lawyer is telling you, what are you going to do? Go find somebody else who maybe will go along with what you tell them you want to hear. But I've seen that scenario play out many, many times.
And that's the reason Sheila says that there are cases she doesn't take, and there are cases I wouldn't take. When I was on the bench, one of the things we offered was through case management conferences, we'd have invite the attorneys or the parties to come in and sit down with another attorney who could kind of help them talk through the issues. And we were able to resolve a lot of divorces that way. When I was family law facilitator before I went on the bench, one of the things I would do is I would sit down with both parties And I would say, okay, here's your issue, here's your position on an issue, and here's your position on an issue. And this is the range of options that the judge has. Can we find something in there that would be mutually satisfactory? And it's just amazing when you can get people to actually talk and not just point fingers.
Agreed. That sounds like the best. And now we've got something here up on the screen. It looks like the dispute resolution continuum. What is this telling us?
So to the left, you see the informal nature of resolution. That's our mediation work that we talk about. And to the right of the continuum is the formal method. So you look to the left, you have more control. Remember, judges aren't making decisions for you. The wonderful thing that I love about the mediation business is that we don't make orders. We help people. I remember going to a mediator many, many years ago, and he says, my best talent is the power of persuasion, to persuade two sides to come to agreement on issues that they can't come to agreement about without some neutral. The costs are less, substantially less. I have seen litigation, and I'm not talking about your average case, but an average case could cost a litigant who doesn't really have a lot of money, $10,000, $15,000. And they end up with results that they're not either happy with, or maybe no results because we never got to that. It's going to cost you more money to go to court. That's not to say you shouldn't have lawyers. It's going to cost less money to go through a mediation process. You have less control in court because the judge in the black dress sitting on the bench gets to decide your future. In addition to that, the parties decide in mediation. That's the informal process. I look at two people, they have a dispute. We talk about options, ranges of options. What could happen if you go to court? What could happen if you come to an agreement? And there are no guarantees, except, as I tell many people, two guarantees in life: death and taxes. Other than that, you have no control. And then if you don't like the outcome, what are you going to do? Maybe appeal and spend another 2 years going through litigation. So the formal method, while we're not saying that it's not a valid method to resolve disputes, there are alternatives that people need to be aware of so that they can look at how they can get through the process faster, easier, with less frustrations.
And I mean, I guess you have to have, if you have a marriage, you have to have some formality because someone has to file a petition. Someone has to, and you have to go to the court to do the first step, and then you ultimately have to stipulate to a judgment of some kind as to how it's going to be so that the dissolution comes through. But it's everything in between can be shortened up. And I have something that I thought of, an example that goes back a little bit to the whole custody thing. I mean, or, family dynamics. I mean, I'm sure you've got situations where one person's in the dissolution process and they're ready to move on with their life, and maybe they've got somebody else in their life and they're ready to move on, and the other person is not there at all. And then you've got the issues about, disgruntlement about somebody else coming into the life of someone but their kids and stuff like that. That could take a enormous amount of time, and you wouldn't even be able to address it until you get to trial and you're calling witnesses and doing all those things. Do you ever have, other people come in, to talk about those things? I mean, who do you include in the mediation? Anybody that's necessary? Is it just the couple?
Generally, it's the couple. They're lawyers. Sometimes I've had experts come in. If there's a business issue, for example, it's not uncommon to have a forensic accountant who may be present, but friends don't get to come. Family members don't get to come, unlike court, right? You can bring your family members, you can bring your friends, and they could all sit there and be your cheering section. But it's the necessary people who need to be present at mediation, and not unnecessary people who will literally, have the parties almost at a litigation phase. They take a break and say, well, that's just not fair. Why should he get more time? You want the parties, their lawyers, their experts. That's it.
Mechanics of the mediation. How much of it is, as I often describe it, you're the mediator, you're doing it, whether it's live or maybe you do it remote by Zoom, I don't know. I don't know if that works with family law mediation quite as much, but you're basically doing shuttle diplomacy between the two warring parties that are trying to achieve a peace treaty for their lives going forward, especially with respect to their properties and their and if they have family members, if they have children, their children. How does that mechanics work? Do you ever have time when they're in the same room at the same time working things out, or is it a case-by-case basis?
For me, and by the way, I've done many private mediations as a mediator and also participated as a lawyer. And so what I love about the mediation process is it's a case-by-case situation. There's
Right.
no one way to do mediations. Here's what I've learned, though, in the years in family law. I do not put the parties in the same room ever, ever. The practice that Dale and I have allows us to have separate rooms for each side where they don't have interactions. I don't want the lawyers to get together and talk law stuff. We go to one room and talk to those folks. We get information ahead of time, of course, but I think it's important to keep people separate because that will create, in my view, and I've done mediations where I didn't see the other side for 12 hours. I think that works in most cases, but every case is different. Sometimes people will come to you, and I've done these kinds of, for example, self-represented mediations where they will be in the same room for most of it because we're talking concepts.
Mhm.
They're not
Right.
there lawyers who can explain different things. It's what I do, and I don't need to do it twice. So sometimes in those self-represented mediations, I'll have both parties in a room and I'll say, what's the issue? Tell me your side. You tell me your side. They can't come to an agreement. And sometimes I use what I call my mediation privilege, which is I'm going to tell you what I think you should do after hearing both of your sides and coming up with a solution to the problem. So they're all different, Peter. I think that it's case specific, and you really want a method that works for the particular kind of a case that you have.
And I would imagine, Judge Wells, you get folks that'll say, ask you the question, well, you're a retired judge, but you're seeing a lot of these cases. How's it going to come out? And you could say, this is how it's probably going to come out if they ask the question, or get them there in a particular way. Like 9 times out of 10, this is how it's going to go. I mean, I can't predict what Commissioner so-and-so is going to do or Judge so-and-so is going to do precisely, but I understand a little bit about what their style is. I understand a little bit about this, that, or the other thing. And here's how it may come out, and give the people that kind of, do people ask for that in your experience, that they want to have some prediction or anything like that?
They don't ask me specifically, well, what do you think this judge is going to do? Or what do you think this commissioner is going to do? Attorneys, for example, already have a sense of where the judges are. That's one of the great things about having a smaller bench, a smaller bar out here in the desert and a smaller bench out here in the desert. And that is that you kind of have a sense of where your bench officers are. And so when you know who's got your case, you can kind of know what to expect and how you need to approach it. So that's true for attorneys. For parties, oftentimes I'll say, well, if I were the one hearing this case and the evidence you just gave me is the evidence that came before me, this is what I'd probably do. And I do that with attorneys. I used to take attorneys back into my chambers and talk to them about what their issues are, what their positions were, and say, okay, now this is what I would likely do if it were coming before me and that was the evidence. And then the attorneys would go out and talk to their clients.
I like when judges do that. That's great. It's great when judges do that.
Yeah.
I mean, you cut to the chase. You're cutting to the chase.
40 years ago, Peter, when I started my practice, that's what judges did. I practiced in Orange County before moving here. You had a case set for a request for order for some temporary relief or a case set for trial. The first thing you did when you checked in, the clerk would say, the judge would like to see you in chambers, or we as lawyers would say, can we go talk to the judge? I can tell you that 90% of my cases were settled in that mode when, instead of presenting ourselves with the arguments and all the briefs we filed with 4 witnesses waiting in the wings, you go in the chambers and you talk to the judge, and he or she would say, here's my thinking. Maybe they read your brief, maybe they didn't, but we had that more. It's rare to see that today. And I'm not criticizing our bench, but when you got 20 cases in the morning, when are you going to have time to do that? It's
Right.
just not possible. So these alternative dispute resolution processes are the next best thing to having a judge weigh in on things. I'll give a good example. I practiced before Dale all of his time as a commissioner and a judge, and he didn't see me there very often because I would say to my clients, well, here's what Judge Wells is going to do. So let's just get this done now. And if he did see me in court, it was probably because the other side didn't want to agree that that's what Judge Wells was going to do. But when you have a bench officer who has that continuity on the bench, when he first left family law, I remember going to him saying, I am going to start a petition to find out why they want to transfer you out of family court. And he said to me, well, actually, I really want to go. I need a break. You guys are good people. I need a break. But when you know the bench officer, when you know how they think, you have a better chance of convincing your client before you spend that time traveling, sitting around for several hours and waiting your turn.
So we have, well, that's extremely valuable to hear that, and people will benefit from listening to that, and it's wise, sage advice. We have up on the screen the dispute resolution continuum. What's the next item of discussion that you think is important to convey the sense of the value of why use a private judge? And we've been talking about it at some length, but you've got some materials to illustrate the point.
Right. This on that continuum, you've got more control if you're using negotiation or mediation. You have less control, of course, least control if everything's in the hands of a judge. You have a kind of a moderate amount of control if you've got a private judge. And there are a lot of benefits. A private judge can be faster, more focused, and less expensive. And here's what I mean. Sheila's made reference several times to the fact that every morning, every family law judge gets up, has a calendar that they've already prepared, and that calendar may have 20 matters on it in the morning. They may have a trial scheduled in the afternoon. All through the day, they're getting requests for emergency orders, ex parte orders. They're getting domestic violence papers that they have to read and they have to pass on to make decisions to protect people. And so that's going on all day long. Now, every day for those 20 matters, the judge has to read the papers that have been filed by both sides. And it may be 15, 20 pages on both sides that have been filed. And the judge, what I used to do is I would go through those papers and I would make notes of what the people had said and what they wanted. And in the morning, I would get up, and when I would call a case and they came before me, the first thing I would say is, okay, I read your papers. This is what you said. This is what the other side said. Now, what did I miss? Now, when I did that, that really caused the people to kind of calm down. It brought down the emotional temperature a lot. Well, what you've got with a private judge is you've got a judge that's focused on one case, not 20.
That's really important.
Cases in the morning, if you got 20 cases in the morning, everybody can only get maybe 10 minutes, maybe 15 minutes. That's about it at the maximum. Right. If you've got a private judge, how long do you need? I recently did a case as a private judge where I had both lawyers, both parties, and both experts, as well as a court reporter in the room. It was a faster process. From the time that they retained us to do it until the time we were actually having the hearing was just a little over a month. And the reason it took that long was because it took us that long to get to a point where both lawyer schedules were free. It could have been quicker, but that's something you can resolve those issues. The attorneys can agree, okay, we want this private judge to handle these issues only, or they can say we want this private judge to handle the whole case. But whatever it is, you can get it handled in a matter of weeks rather than a matter of months or even years. So it's faster focused. Because of that, it's less expensive. On those days when you're one of 20 couples sitting in the courtroom and your attorney's sitting there, their meter's running that whole time they're waiting for their 10 or 15 minutes before the bench officer. In this case, basically everybody's meters start running when everybody shows up. And it's only the time that you actually spend on that case that you're paying for. It's less stressful and more relaxed. it's not uncommon for me in a private judging scenario to have everybody refer to each other by first name rather than attorney so-and-so and, Mr. So-and-so, Ms. So-and-so, that sort of thing. And that brings down the emotional level. It's less stressful. It's more relaxed proceedings. You can take a break when you need to. You can come back. You can let the parties go talk to their attorneys if they need to. It's just a whole lot more flexible. And not only that, but you're dealing with more experienced family law judges and practitioners. The law allows for parties or attorneys to ask for a particular attorney, family law attorney, or family law judge, retired family law judge, who's a member of the state bar, to sit as their private judge. And so you've got someone like Sheila with 40 years of experience who can sit there and hear cases and make orders on those cases. You've got somebody like me who's got a lot of years of experience on the bench. Now, the key to all of this is the parties have to agree, we want this person to be our private judge. They submit that agreement to the judge who has the case. The judge who has the case then signs off on it. And that makes me, or it makes Sheila, the judge for those issues that are laid out in that stipulation. So it's really a process where you can get more experienced family law practitioners. You get them in a less stressful, more relaxed proceeding, and you get things done in a faster, more focused and less expensive way.
And by the way,
what we're talking about now, is not mediation. We're talking about a reference judge, right?
Exactly.
Correct. Yes. So I wanted to.
The parties pay the fee. Now, let me ask you a question. Overall, you're going to pay for the judge. Each side's going to contribute whatever they're going to contribute, however that works out. It could be narrowed to specific issues, and then that becomes the ruling of the court. So you expedite that rather than going down for years to have your 15 minutes. You're compressing it, but there's an expense for the private judge. It's different than mediation. You're paying for the mediator, and it's a voluntary thing, and you hope you get an agreement. With a private judge, you will get a decision.
Yes.
And the private judge, you're paying for the private judge, but where you're really saving the money is on your lawyer's fees and the respective sides, because you're getting to it, I would imagine, exponentially quicker than you would possibly get it in court.
Oh,
and
absolutely.
that's a very big and very good point, Peter. And the other thing I was going to point out is that not many lawyers, and I've been around here for a long time, understand that they can actually hire Dale or myself or any other experienced family law attorney to be a private judge through stipulation by the court. People think about mediation, which is perfect. The problem with mediation is that if they don't come to an agreement, and we'll talk about that later, we haven't settled the case. But many lawyers don't know that possibility. I see that in Los Angeles much more than I see here in the desert. I've been appointed probably 5 times in the last 10 years as a private judge on a case where the judge who was assigned the case signed a stipulation that we prepared, allowing me to make those decisions. And then I had the ability to schedule conveniently and quickly. And when people walked into my office for their private judge case, I was ready to go. Nobody had to wait and hear other cases. There was no embarrassment, and it was quite smooth.
Now, quick question before we go on to the next slides. I know you got a lot of interesting information on those slides. Quick question. When you are the private judging, can you relax the rules of discovery, or what do you do? Or is it do you set different, or you could do it by stipulation, I suppose. It depends on what the attorneys want to decide.
Exactly. That's the way I handle it. Basically, I ask the attorneys, okay, what do you stipulate to coming in? Do you stipulate the foundation of these documents? And if they're willing to use a private judge, they themselves want it to be more relaxed and less formal. They want their clients to feel more relaxed and less formal. And yes, even though we have a court reporter, that's one of the reasons I use first names instead of Mr. and Ms. So-and-so in the process, because I want everybody to feel comfortable. But yeah, I can relax the rules to the extent that the attorneys are willing to relax the rules.
And one thing prospective litigants watching out there, and this would be true in a family law setting, it's true in any court setting, certainly true in trust and probate litigation. When you go down, when you just don't go down to court and get to talk. You get in the box, you got to introduce evidence. It's a formal process.
Mm-hmm.
We all love it. It's what we do. But that conversation is not something that litigants really want to have. And when it's only going to be in that 3 hours, I don't think there's a family law court in Southern California that operates different than we do. You don't get all day anywhere, do you? You get certain days in the afternoon. It's going to be from 1:30 to 4:30. So you don't even get a whole day. But if they go to you as a private judge or as a mediator voluntary, private judge voluntary up to the point that you pick the private judge, but then the judge is going to decide. That private judge is just like a judge as to those issues, but it is expedited, and it's not in a narrow window of time of 3 hours every afternoon, which is the most that the courts can give us on these kinds of cases. Is that a fair statement?
That's a fair statement. One of the things I do, and this is I think important, because you mentioned that the parties don't usually get to talk very often in court unless they're sworn in on the stand. So what I'll do is at the very beginning, I'll have everybody that I expect to offer evidence. I'll have everybody sworn in at the same time en masse. And that way, as we go through, if one person says something, another person then responds to it or something like that, it's all on the record, it's all under oath, and it's a much more relaxed setting than the formal setting with a person on the witness stand and the attorneys going at them.
So we've covered this on this particular slide. We have very interesting. Why use a private judge? What other information do we have? Then we're going back. Why mediate?
Mm-hmm.
Right. So on the screen now we have a slide that talks about several items that are critical in these situations: decision making and control. I'm going to take the mediation side. Dale will take the litigation side. But under decision-making and control, parties are in control and can make decisions based upon their family's needs.
In litigation, the lawyers and the judges are in control, and they have a limited range of options available. Unlike mediation, where the parties can agree to something that the judge couldn't otherwise order, the judge and the attorneys basically call the shots within the limits of the law.
In connection with costs, the mediation process is cost effective. We've already talked about having your lawyer at $400 an hour, whatever they charge, sitting around for hours waiting for your 15 minutes of argument. It's more cost effective. By the time they come into mediation, the clock starts when we start, and they're not spending their monies on other people's cases.
Absolutely. Litigation is expensive, no matter how you look at it. The cost of discovery, the cost of experts, the cost of the time that even the experts and the attorneys are sitting in court waiting to be heard. It's just financially draining. It's not uncommon for people to spend $20,000, $30,000, $40,000 on maybe their lawyer, and maybe that much on experts too. Before you
and even much and that almost sounds low, right? Of the potential of what it could be, depending on what it is I guess it depends on the dispute. Size of, what the marital assets are and all of that. But yeah, that seems almost like a built-in ticket right there. You know what I mean? It's like, it's just to get to do the things that you have to do would almost at least cost that much for most people. So if you could get to these other alternatives as quickly as possible, it's certainly helpful.
If you've got
one down there about impact on children is in this area seems particularly helpful.
On the expense, if each side's got a lawyer at say $20,000, that's low, and each side's got an expert at, let's say, $20,000. You've got $80,000 in a case before you ever have an order.
Right.
And then you've got the time that they're all in court on top of that. So you're at $100,000 or more between the two parties. With mediation, you cut that dramatically.
In my experiences, maybe 10 years ago, I was involved in a case that required that I travel out of state to take a deposition of a lawyer in connection with a prenup. Not only did I fly out, we spent several days there, preparation time, court time. The case actually went all the way to trial. And by the time the case was over, by the way, 2 people, no kids, a prenup, 2 weeks of trial, afternoons only. The legal fees on the entire case were just shy of $1 million.
Well, that was a that's a
And by the
Hollywood
way,
thing.
those are numbers that people who listen to these podcasts are not even going to be able to relate to. But the point is this: we're not fighting about kids. We're not fighting about businesses. And, just the kinds of things that were necessary. And sometimes things that I do are not things that I would necessarily do as a litigator. But unfortunately, if I've got a deposition to take out of state, I got to travel. And forget the sitting in court waiting for your 15 minutes. I leave my office and I'm headed to the airport, and I'm on the clock when I leave until I get
the things you have up on the screen. It seems like when we compare mediation to litigation in the categories of confidentiality, emotional atmosphere, impact on children, meeting tone, and the impact on children minimized, the needs of the children remain central to the decision making. That seems to be something that could be focused on with a more a mediated approach better. The duration of the process and future interactions. It just all makes sense what you've got up there. Other guidance that you can give from this presentation. What I know we have some other.
Let's go to the disadvantages of mediation, Peter, because I think we've got some good points there, which will kind of summarize some of the other things we could talk about. Mediation is not compulsory. Either party can withdraw at any time. I rarely see that happen.
Disadvantages. Although, wouldn't you say that when most people get there, they tend to finish it? In my experience of what I do, I say if you go to mediation on a trust and estate litigation, it's a very high probability that you're going to settle that case. You might not settle it on that first round of mediation, but you'll eventually get it. And I say if people agree to go,
right,
they usually do. And I'd like you to relate that to your experience in family law court. Right. And if there's like a kind of I don't know if there's a percentage statistic about it. But
I personally feel I closed my full-time law practice a little bit under 3 years ago. And since that time, I have engaged in primarily mediation work and to a degree, self-represented litigants. And as of today, I am at 100% settlement rate. I have settled every case that has come to me.
That is fantastic.
So the point that you make, Peter, that's a good point, which is people wouldn't agree to this process unless they had the state of mind to say, I need to get this over. I'm tired of spending legal fees. It's been years. So people walk into my process, and also with Dale, wanting to find a resolution that's going to work. So while you can talk about the disadvantages, courts can't make you do it and you don't have to agree. But part of my job when I do private mediation work is the power to persuade people that they don't want to go to India. They don't want to spend a lot of time and money on legal fees. They don't want to fight about kids and their needs when they know best as parents what those needs are. And so when you explain things to parties that way, while it may not be a compulsory process and they can say, I'm not going to sign your agreement, I haven't had a case where they haven't. One guy said to me one day, he says, well, maybe your 100% rate is going to change. I said, well, give me another session and we'll see what happens. And we got
you will do multiple sessions, of course. And the other thing that I think is, it's a disadvantage, but it's a disadvantage that can be easily avoided. You don't want to have an unskilled mediator. You want to have a skilled mediator, and of course, you got a 40-year attorney and a person who was the judge, so you got a lot of experience there at your firm, your mediation firm. So retired judge and a person who's practiced for 40 years, and then the concerns about enforceability. You got 664.6 for the marital termination agreement, but do you convert it? Did you convert it? Like say, we're mediating this, but we're going to convert this to the appropriate orders that become the judgment, and everybody says yes, and then it's done.
So before I finish my mediations, I will do one of two things. I will have a signed mediation agreement, or in those cases where I have multiple sessions, I'll actually prepare a marital settlement agreement or a stipulated judgment for the parties to review and sign. And now it's enforceable. You can't leave mediation without something in writing. And if you don't have all the I's dotted and the T's crossed, then lawyers will fight about what that language should be. So it's my goal at the end of the process to have a document that is clearly enforceable pursuant to the CCP 664.6, and the parties can walk away knowing it's over.
And for folks out there not familiar with the abbreviated lingo that we lawyers use, it's California Code of Civil Procedure 664.6. If you agree to something in writing outside of court, it can be enforced. It can be enforced if you sign it. If you agree on the record before the court, it can be enforced, and there's no going back. And the courts generally want to enforce those agreements, and they're very rarely, in my experience, not enforced.
Yeah. I'll even put that in the agreement itself, in the marital settlement agreement, that this is enforceable pursuant to 664.6. That way, when they sign it, they're signing the acknowledgement of that statute.
Terrific.
Good.
And now we have, this is California Rule of Court. We got something about the California Rule of Court 5.98. What does that tell us?
Well, one of the things that we said as a disadvantage of mediation is that it can be wasted if you don't reach an agreement. But it really can't. It really is not wasted. And that's because of Rule of Court 5.98. Attorneys who appeared in front of me for years knew this was just about my favorite rule. It is a rule that says that the attorneys and the parties have to meet and confer. It's requirement. They have to do it in person, by telephone, or as ordered by the court before the date of the hearing relating to a request for order. They have to make a good faith attempt to settle all the issues. Now, you can't use it in cases involving domestic violence, but the idea is the law does allow the court to require people to sit down and talk. Now, I can't require them to be reasonable, but I can require them to talk. And the law, CCP 5.98, requires them to make a good faith attempt to settle all the issues. During that, they have to exchange all relevant documentary evidence. And the court, when it comes to court, if one side held back and didn't share some documents, I can reject them. I can ignore them because they weren't shared at the 5.98 meeting. Now, that doesn't apply to...
That rule of court is particular to family law proceedings.
Yes. That's particularly for family law proceedings. It doesn't apply to rebuttal or impeachment documents. But that's a critical thing right there. Even though we can't force people to mediate, we can force them to meet and confer. We can force them to go through the process, even if they're just doing it in a perfunctory way, of sharing what they intend to share at court, and knowing that if they don't share it, that the judge can reject it.
Well, I was going to ask you that question because my experience in trust and estate litigation, we have a case, Breslin v. Breslin, a 2021 case for the lawyers out there at 62 Calab 5th 801. The court can order you to mediation. It's actually pretty powerful because if you're ordered to it and you don't go, if you got a variety of errors, it could still be enforced against you, right? If you don't show up and you had the opportunity to show up. Little bit different wrinkle than what maybe CRC 5.98B says in the family law setting. But the theme of it is what you're saying. We could order you to try to settle, but we can't make you settle.
Right.
Right.
And what I would often do on the bench is when people came in front of me, I'd say, okay, tell me about your Rule 5.98 compliance. And if they didn't comply, then I would take their matter off calendar and make them comply before they came back. Or I might continue the matter and make them comply before they came back.
And I've seen him do that, by the way, or he'll send you outside to go do your meet and confer. And here's the form, and you fill it out and you bring it back when you're done.
And lawyers watching this out there, but litigants watching this out there, when you hear this language about all of these things that we're talking about, imply court proceedings of great formality that, like I say, we all love to do it, but the people aren't gonna love to do it when they're having to do it, right? Of
Right.
how you have to introduce evidence, how you have to do all these things. So the cutting to the chase, of a mediated result on things that two people who, like you said at the beginning, Your Honor, like you said at the beginning, like you said when you open your court every day, when you were on the bench, you'd say, well, you used to get along at one point enough to get married, enough to maybe have a family. You can maybe pull that up out of your memory and try to do it again as you both try to move forward in your lives. It's just a wonderful concept. So the right time to use ADR.
And we've talked about that a lot today, Peter. But I'll emphasize just a couple of points, and that is, start at the beginning of the case, talking about the concept. You may not be ready for your mediation, day one or the first month, but you can start setting up the possibility that at some point in time we will have a mediation or some alternative dispute resolution. And there's a variety of issues. Data separation, sometimes litigated. Parenting plans, very big issue in courts. Child support, spousal support, arrears, property division, including business analysis and valuations, pensions and buyouts, and other issues that we call pivotal, which once they get resolved, then the whole kind of other smaller issues and things that are less important go away. So we're amenable in alternative dispute resolution to talk about anything that a family law court could resolve and make a decision about.
That's wonderful. Here we go. Choosing a neutral. This is we're getting close to the end of our time here, but if there are there things that you also would like to impart to?
I think you know enough about us now, and the people watching the podcast know enough about us now to see that we are in the business of trying to settle things, not litigate things. Sheila with her 40 years of practice, me with my 30 years on the 30 years of practice, and nearly 20 on the bench. We've got a lot of experience. We're known in the legal community. People know, they have a sense of who we are and how reasonable we are. And that should, I think, make them feel comfortable coming to us.
I would, yeah, definitely. The experience of a judge has been on the bench for 19 years. Someone who's got practicing for 40 years. The possibility that you can greatly shrink your matter down to a manageable time frame where you can get closure and end the anxiety of it and have a predictable future, and maybe, like you say, control things, in a way that is fair and without acrimony, and has the full attention of the people who are doing it. I mean, judges are human beings, like you said. You got somebody who's on the bench. They got 20 matters in the morning. And then they're going to focus on your matter in the afternoon, but there's still other things going on in their head about what they got to do the next day. I mean, the bench officers are wonderful. They do a fabulous job. They do the best job they can. But if you're trying to plan for your future and make this work right, this just seems like a very wise decision for people to make. And we got in a nutshell here.
Right, and I just want to make one final comment with regard to that, Peter, and that is that during my practice, there were very few lawyers in the desert who took advantage of these ADR processes. You guys in civil are sometimes required to do certain things, but in family law, we were not. So I've always been disappointed that the family law bar in the desert specifically, and I know every lawyer here, have not taken advantage of that process. That doesn't mean that every one of their cases has to go through mediation or private judge work, but you have those cases that get out of control, that take over your practice. I would have in a typical situation in my practice, if I had 30 cases pending, I had a staff of 3. And of those 30, 3 of them were out of control cases. Those are the ones that I should have been flagging to go to some sort of ADR process. It also took the other side to agree to that. So when I gave up my full-time practice 3 years ago, I contacted Dale and thought, what we don't have here in the desert is what we're offering here.
Mm-hmm.
A lawyer,
a focused family law mediation
Mm-hmm.
with experienced attorneys and a judge in family law that is a resource for the family law community. But you're not limited to the desert. You can take cases from someone comes from.
We can take cases wherever we want. But the other piece that is also important, Peter, is this, and for those people who listen, and you have to have a level of confidence and respect for the person that you choose to be your mediator or private judge. I believe we both have that reputation here. Because when you go in front of a bench officer who's got experience, as I did with Dale when he was on the bench, I would, if he gave a ruling against me, I would accept it because maybe he looked at it a little bit differently than I did. But having respect for that person, knowing that they have the expertise and the ability to communicate effectively with people is probably the biggest part of our jobs. Everything else is pretty straightforward.
Well, this has been extremely illuminating. It's all about being a problem solver, and look for creative solutions. Try to help. What will help this family? All of these things are just wonderful points to consider as people contemplate how they have this problem in their life. They have a problem in their life. They got to resolve it, and you can take the path of, I guess it's the path of wisdom to explore resolving these kinds of painful disputes in a mediated setting. And I think you've imparted a great deal of valuable information to both lawyers and prospective litigants. I'm honored to have you on board the podcast, and thank you very much for sharing with us, and I hope you come back. And
thanks for having us.
Thank you so much, Peter. Love to come back.
That's it.
You've been tuning in to Your Inheritance, Your Rights, Your Obligations, Your Responsibilities with your host, Peter Bochnewich. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find the show at www.wetrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.